Hello, everyone, and welcome. Welcome to our Lunch and Learn September edition. September is almost done, heading into October. Hope everyone's having a great day today. For those who are not familiar with my name is Maya. I am the senior HR consultant with H2R and your host for today. As you can see, you have been muted, but if you have questions throughout the presentation, please use the comment section or the Q&A box. This month, I'm really happy to welcome our dear friend Evan from Filion Wakely to provide us with updates on the legal front. And we have Kirsten Smith from OCTC talking to us about transforming workplaces through disability inclusive hiring. Looking forward to both of these presentations. So welcome speakers. It's really nice having you here with us today. Evan, you ready to do this?
You betcha.
All right, over to you.
Thank you so much. It's great to be here on a rainy Wednesday.
Mhm.
So as mentioned, the plan today is to spend about 20 minutes just touching on some recent changes, both from a legislative perspective and also some recent cases that we're going to really focus on in terms of termination clauses and employment contracts, which I know in our past sessions we've touched on as well, but a good reminder given the development in the law. So let's jump right in. And I'll say from the outset, happy to take questions throughout the presentation. Happy to hang around at the end to answer questions as well. So don't hesitate to jump in on the Q&A box and fire questions or comments as we engage in this discussion. So let's jump into some of the recent statutory changes. And so the Ontario government's keeping us all busy, all on our toes, making sure H2R and myself have lots to do by implementing lots of changes to legislation. And so I think every time I've spoken in these sessions, there's been a new Working for Workers Act coming out. And so we have the Working for Workers 6 Act, and we also have number 7, Bill 30, which is in the process of going through the legislative steps to be passed. So let's touch briefly on some of the changes. Maybe go back one slide, sorry, Brad, under the Working for Workers 6 Act. And two leaves that I would flag for everyone to be aware of. Firstly, we have the long-term illness leave, which is in force now. And the second leave, which not in force yet, but is placement of a child leave. So let's maybe unpack those a bit. So as I mentioned, this placement of a child leave is not in force yet, but will provide an employee with a 16-week job protected unpaid leave as a result of an adoption or surrogacy. So again, we don't have a firm date yet to be proclaimed as to when that's enforced, but something to be mindful of. The second leave, or new leave, I should say, which is in force, is this long-term illness leave. And it provides 27 weeks of a job protected, again, unpaid, but a job protected leave. And as you can guess by the descriptor, it's in relation to an individual who's suffering a long-term illness. And so that individual must have worked for 13 consecutive weeks prior to becoming ill. And of course, there is some parameters around the ability to seek confirmation as to the illness. Now, obviously good to remember that in addition to the statutory leaves under the Employment Standards Act, we of course as employers have obligations to accommodate under the Human Rights Code. And so even though we have these leaves around illness and child leaves, of course, the other major statutory regime under the Human Rights Code also imposes obligations. And so the point being is, for example, under a long-term illness leave, even though the 26 weeks may come to an end, if that person is still suffering from that serious illness, your obligations to accommodate may require that you continue to allow them to be on a leave. So important to remember that we have these job protected leaves under the Employment Standards Act, but really that provides some floor of rights for the employees, but we also have obligations under the Human Rights Code which can provide more in the sense of extending obligations beyond these strict parameters. So, kind of a good reminder there not to jump to the gun and think that we can just proceed with ending the employment relationship, for example. So those are the two leaves under the Working for Workers 6 Act. And I would just flag that act also made changes to the Occupational Health and Safety Act, made some changes to the Workplace Safety Insurance Act. So other changes. I don't think we need to get into too much of those changes, but just flagging for you that these two leaves, but there's some other tweaks to those legislations as well. So let's jump in and talk about the Working for Workers 7 Act. And again, as I mentioned, this is going through the legislative process, but similar to the other six Working for Workers 6 acts, it modifies the Employment Standards Act, the Occupational and Safety Act, and the Workplace Safety Insurance Act. And that's usually what we see with these changes. So let's jump ahead, Brad, and we'll dive into what is being proposed. So again, some of the things that are being proposed under this new legislation, firstly, is the requirement for the platforms to implement some mechanisms for users to report fraudulent publicly advertised job postings, which is kind of interesting. Again, so we're thinking of the Indeed, the LinkedIn's of the world, where there's a process by which we can identify and deal with fraudulent job postings, because it is a bit of an issue out there. I've heard from various clients. So that's one piece of it. Other points of note is again, another leave that the government is proposing, which is a job seeking leave, which is interesting. And so this would allow an employee who's received notice of termination up to 3 days unpaid, again, unpaid being the important part, to engage in job searching activities. So job searches, of course, interviews, training, etc. Now, one really important qualifier on this is that it only applies when we're dealing with a mass termination. So under the Employment Standards Act, we have the rules that deal with the vast majority of dismissals, but then there's special rules where an employer is terminating a certain number of employees, 50 or more in a 4-week period is the standard rule. So if you're in a scenario where we may see some of this in the upcoming year, downsizing of organizations, and we're hitting that mass termination threshold, then it would trigger the entitlement for the employee to have these 3 days of unpaid leave. Whether that's a significant change, I don't know if it is, because a lot of clients I deal with who are going through this process already provide some time off to permit these activities because, of course, they want the individual to find alternative employment quickly. But again, more so of a compliance piece for any of you who may have to, unfortunately, go through that process, to be mindful that this may be a legislative requirement. The other additional change under Bill 30 would be extending the time periods for a layoff. So as many of you know, currently the Employment Standards Act really has two stipulated time periods, the first being 13 weeks and the second being 35 weeks in a 52 consecutive week period if we're engaging in certain things such as continuing benefit coverage. And so the government, this new Bill 30, is proposing to enable to extend that time period to essentially a year, 52 weeks in a 78-week period. But here's the kicker. It has to be an agreement with the employer-employee. So I'm sure some of you are thinking, well, we're laying off someone for a year. Why would they ever agree to that? Which I think is a very valid question. But there may be scenarios where rather than losing the job and losing access to benefits and other entitlements, the employee would consent to a longer period. And, we've seen even during, some of the COVID times, employers engaging in longer layoffs without having recourse by the employees or the employees not advancing claims because the employees kind of bought in that this was a necessary step to protect the long-term viability of their employment with the organization. So again, one of those things we'll have to see where it lands as we work through the legislative process. But to the extent it's passed, it'll be another tool in our toolkit if we're dealing with those ups and downs of the economy. And if you as an organization are experiencing a significant downturn, which you think may last a year, but then you're going to have that, that upturn again. Again, another tool in the toolkit to potentially navigate those downturns. All right, let's keep rolling. So other changes to the Occupational Safety Act would be first, as you see in the slides, potential reimbursement for the cost of the defibrillator. And I would say the bigger potential area of concern would be the introduction of the administrative penalty scheme. And so many of you likely have experienced the Ministry of Labor inspectors attending your workplaces, engaging in routine inspections, checking if you have your harassment policy, checking if you're, meeting the obligations of the act. And usually if an employer is not, what happens is there's compliance orders issued. And I would say probably the vast majority of times an inspector attends a workplace, they're giving you something, right? They're giving you oh, hey, you need to tweak this, you need to tweak that. And that's because there's a significant number of steps employers have to take under the act. And batting 100 every single time is challenging for employers. And so the introduction of this scheme could result in, as opposed to right now just having this compliance order that you have to comply with, the potential for those inspectors to actually issue penalty notices. And that would obviously have monetary consequences. So again, not in force yet, but to the extent it is, it's adding even more importance on ensuring compliance with all of our obligations under the Act. And I'd also say right now, a lot of employers simply accept the compliance orders issued by the Ministry of Labor, kind of at face value, and just comply because it's cheaper than calling Evan or other lawyers and saying, should we take issue with this? Once we introduce monetary penalties, then my suggestion is you may want to have a more critical examination of what has been determined and has it actually been a breach of the act? Are you actually offside or just simply complying and paying? So again, to be seen how this plays out, but a potential point of concern for employers. Other changes would be to the Workplace Safety and Insurance Act. And before I touch on this, I'll touch on that quickly, which essentially, again, imposing the potential for penalties under the Workplace Safety and Insurance Act for employers. So again, something to be mindful of. So those are what may come down the pipes as we work through the rest of this year into next year. I thought it'd be helpful just to touch very briefly on some of the changes we've talked about in my past sessions, and I believe Catherine, my colleague, in her last session with this group. And so firstly, we have new requirements that are in force now, July 1st, for employers with 25 plus employees of certain information we must be giving to employees before or essentially on their first day. And so you see that information on the slide, but I think from a compliance checklist perspective, hopefully all this stuff is in your offer letters and your employment agreements, likely is if you have employment agreements. If not, again, I think it's quite an easy kind of check the box just to make sure this is in your offer letters and employment agreements. And then as of Jan 1, 2026, we have some further requirements around job postings and interviews. And again, those are listed on the slides. And to the extent you're engaging in recruitment activities, be mindful of these from a compliance perspective. Again, making sure that if we're having comp, we have the appropriate ranges. There's the requirement to disclose the use of AI, which I think is quite interesting, whether the posting is actually for an existing vacancy. I think we saw the last couple of years, given the difficulties retaining talent, people just having postings up constantly for jobs. And we still sometimes see that for like DZ positions and things like that, which are constantly challenging to fulfill. So you have to be mindful of what's actually a vacancy and what's not. And then the last piece of this is advising candidates as to the hiring decision within 45 days, meaning of those of you interviewed, meaning, sorry, not hiring you, wish you the best. Does not, we don't have to get into a robust report as to the outcome, but just, indicating where things landed in that process. Last piece on the legislative is just wanted to touch on, of course, the increased minimum wage coming up quickly. We were just, when I was chatting, it's amazing how October 1st is already here. So just flagging that for everyone. Let's go to the next slide, Brad. And so, other piece I wanted to flag, not so much, it somewhat touches on some of the employment legislation, but I thought it'd be of interest for some of it, of us in this group around amendments to the Ontario Labor Mobility Act. And I think we've all heard in the news about the desire to make or allow workers to kind of move within Canada to ensure we remain competitive and in response to some of the impacts in their relationship with the US. So this is one of those changes which has happened, which essentially for non-health, that's a key piece, certified professionals, the ability to go work in other provinces up to, or sorry, come work in Ontario from other provinces for a period up to 6 months. So again, I just flag for all of us to, who may have shortages or hiring challenges for certain professional positions, that this now even extends your labor pool broader. Historically, if we had certified individuals, we may have been restricted to Ontario just to mitigate some of those challenges in approving work, etc. But this is, I think, a good news piece for employers for certain positions. So flagging that for consideration to the extent you are involved in, engineering, accounting, some of those certified professionals, you may have a broader labor pool. So let's move on. And in my last 10 minutes or so, let me touch on a few case law highlights for everyone to be mindful of. And what I wanted to do in our session today was focus on termination clauses in employment agreements and the cases that we've seen over the last 12, 24 months that are relevant to this and more, even more recent than that. And I know in the session, our last session, in the spring, I believe, we touched on the many benefits of having sound employment agreements, with one of the biggest being the potential to minimize your termination costs in the event it doesn't work out by essentially eliminating the employee's right to common law reasonable notice. But to be successful in that objective, the devil is in the details because courts do not particularly like termination clauses and are quite onerous in how they analyze and find ways to strike down those clauses. So that's the background. Let's talk about some of the cases. So let's jump ahead, Brad. And so as you'll see when we get into these cases, there's some recent cases which are very positive for employers, which have upheld termination clauses, which is fantastic. But also we have a string of cases which have done the opposite, have struck down termination clauses in employment agreement. So still, I would say slanted more in favor of employees in terms of these clauses being found unenforceable. But we do have some good news story. And the first is this data stealth decision from this year, which essentially the Court of Appeal, which is the highest level of court in Ontario, upheld a termination clause. And that clause essentially specified that if the individual was terminated, they would be provided only the minimum payments and entitlements, if any, owing under the Employment Standards Act and regulations. That was essentially what the termination language said. And if I'm sure many of you use the H2R standard employment agreements, and you'll have some comfort, that's how those are drafted to be consistent with the Employment Standards Act. So again, the positive of this is, I think, a couple of lessons for us as employers. Less is likely more. Sometimes I see termination clauses drafted which are like a page long and get into every single scenario and oftentimes trying to cover off every scenario means you miss something, versus just taking a more simple approach can actually make it more enforceable. So I think A good takeaway from this case is reassurance, both in how H2R is drafting its contracts, but also just the general strategic mindset of less is probably more when we're drafting these provisions with employees. Let's jump ahead to the next slide. The other kind of trend we've seen in the cases dealing with termination language is concerns that courts have with the use of at any time. And so again, I'm sure many of us have seen employment contracts which talk about, we can terminate your employment at any time. We may terminate your employment at any time without cause upon providing you with, X, Y, and Z. And so courts have focused in on that specific wording, of course, at the behest of plaintiff side counsel, but that has gotten some traction. And there's been essentially 5 decisions, which we'll touch on very briefly, with deal with this. And so let's jump ahead, Brad. And so we have 3 cases, which essentially different levels of court have said that at any time can make your termination clause invalid on the basis that it contracts out of the requirements of the Employment Standards Act, or may contract out. And the logic behind it being that in theory, there are times when, under the Employment Standards Act, it is not permissible to terminate an employee. For example, if someone's on a leave of absence, or if you're terminating them due to their attempts to enforce their rights, that would be a reprisal. That would be a violation of the Employment Standards Act. So the court's logic is, well, if you say you can fire at any time, there is a potential you violate the Employment Standards Act, and therefore your clause is offside the Employment Standards Act and invalid. So that's the string of logic. There's some, I think, concern about the validity of that argument, and we see these other cases which have arrived at other conclusions. So let's jump ahead to the next slide. We have 2 cases which found that it doesn't contract out of the Employment Standards Act. So you'll see the 2 cases on the slides. And again, the key takeaway was that the court said, well, just because you say at any time doesn't mean that you are firing when someone's on a maternity leave, for example, or when someone's raised issues. So that wording does not result in the provision as a whole being found invalid. The big takeaway, I would say, for us, other than the interesting fight between the courts as to who's right, is let's not use those words. Let's sidestep this whole issue, be proactive, and hopefully not get into this kind of quagmire about, well, which decision's right and how do we differentiate our clause from the decision. So I think the takeaway for all of us is going back, checking on our offer letters, checking on our termination clauses to see, are those are those words there, and how can we tweak it to sidestep and mitigate this whole issue to ensure we have the best chance of enforcing our termination clauses. So with my last few minutes, just a couple of takeaways for employers is, of course, termination clauses have significant benefit for all scenarios where we're terminating. And so we want to have offer letters, we want to have employment agreements. I always suggest to organizations that this is one of those HR action items, every year, ideally, every 2 years at the most, because the law changes so much. It's one of those January to-dos, like check in, what's changed, is ours still enforceable, how do we make it better? And it's one of those slippery slopes that we're trying to get it perfect, which it will never will be. But so point B, constantly update. In terms of the next slide, we've talked about, ensuring that our written offers comply with the new transparency requirements. Like that's a compliance action item. And then I think it's a good chance as you're leading into the end of this year to prepare for some of those job posting requirements. So a good chance to audit, make sure you're in step with what's coming is another good compliance action item. So I'll stop there. Happy again to take questions now. Of course, I'll hang around to the end and happy to take questions then as well, or even via email if that's preferred.
Thanks, Evan. Um, can we clarify something? I don't know if the audience also has this question, but at any time, the wording, would you recommend just removing it altogether, or not use it so much because I've seen it before in, employment contracts. So what do you recommend?
Yeah, I think we don't use it. And
Okay.
here's my nuts and bolts, very quick for a lawyer response, which is I think the reasoning of the court's silly. I think there's good, sound arguments why those decisions are wrong, but let's not have the fight. Let's avoid paying me to have that fight. So let's draft our termination clauses to not use that language so we don't even get into that debate with opposing counsel.
Okay. Okay. All right. Well, thanks so much. That was very informative as always. Again, if you have questions, you can use the chat box or reach out directly to Evan. And now welcoming Kirsten. Welcome. Take it away. Looking forward to your presentation.
Wonderful. Thank you. Hello, everyone. As Maya said, my name is Kirsten Smith. My pronouns are she, her, and I'm here on behalf of the Ontario Corporate Training Centre, OCTC, one of the many projects of the Ontario Disability Employment Network, ODIN. And we are committed to transforming workplaces through disability inclusive hiring. And what I'm hoping to share with you today, if you can just wait on the slides, just head back a little bit. You can pause right there and I'll get to that in just a moment. Thank you. I want to share with you a bit about the OCTC project, the landscape of disability in Canada, and how you can get started or deepen your disability inclusion journey as an HR professional. And to give you a little bit about who I am and my background, I bring expertise from the educational, nonprofit, and for-profit sectors, specifically in training and development, curriculum design, project management, business leadership, and of course, building strong and effective community partnerships. And I am incredibly passionate for many reasons, personal and professional, about creating more inclusive workplaces across Ontario and helping businesses tap into the talent and potential of people who have a disability. Now we can move to the next one. So the Ontario Corporate Training Centre, OCTC, is a province-wide project designed to offer research-informed training, resources, and services to businesses across Ontario. As I said, it's supported by ODIN and funded by the Government of Canada. OCTC's goal is to foster strength-based collaborations and transform the employment landscape for people who have a disability. This project is a project that designed training and services free for businesses within 4 sectors, and it runs until January 2026. However, there are a number of ODIN trainings and initiatives that businesses can partake in, both free and fee for service, to strengthen their disability awareness and confidence. And for those who may not be familiar, ODIN is a nonprofit organization that was created to be a network of employment service providers working together to increase employment opportunities for people who have a disability. And ESPs are agencies I'm sure you're familiar with that specialize in connecting qualified job seekers to meaningful employment. Not like a placement agency or a temp agency, they are government-funded organizations designed to support people in finding employment. So we can move on to the next slide. Before we dive into looking at disability, I just want to touch on some of the current challenges that were the reason that this project came to be. So some of the highlighted challenges forecasted by the Ontario Chamber of Commerce were the economic uncertainties we're all seeing that is affecting employment, consumer spending, all kinds of issues in business. Productivity has fallen below pre-pandemic levels, and that downward trend is expected to continue. And those experiencing labor shortages in their sector identify that the lack of available skilled workers and challenges in attracting and retaining talent as the main causes, which I'm sure you folks are very well familiar with. And a significant percentage of businesses also believe the retirement of experienced employees to be a primary reason for a lot of these shortages now and in the future. So to navigate and withstand these challenges, one of the core strategies that they recommended was for businesses to invest in their people, talent, and skilled workforces. And it's been shown that businesses who follow these types of recommendations and invest in becoming more inclusive grow their profits up to 3 times faster, according to Gartner HR. So by participating in either the OCTC project or other Odin initiatives, businesses can really take meaningful steps towards investing in their workforce and strengthening long-term resilience. So I want you to just have a peek at this one slide from one of our training modules, People Who Have a Disability, the Facts. And this slide highlights 5 key facts about disability in Canada right now. And it's really important to understand this landscape when we're having this conversation. More than 1 in 4 Canadians, that's 27% of the population, over the age of 15, self-identify as having a disability. So this means that disability is not a future conversation. It's not how can we or when we hire somebody who has a disability. It's already part of your workplace now, whether visible or not, because disability is a broad term which includes both visible and invisible disabilities and mental health. And it's important to recognize that 850,000 Canadians with disabilities are unemployed, despite being ready, willing, and able to work and having comparable education to people without disabilities. So this is a significant untapped talent pool that could help address labor shortages in your organizations and meet your business's workplace needs. Beyond addressing the labor shortages, inclusion is a proven business advantage, and highly inclusive businesses have been shown to, they're 120% more likely to meet their financial targets. And that really just demonstrates that investing in disability inclusion, it's a smart business strategy, not just, the right thing to do. We can go to the next one. So when you think about, when you reflect on, your experience with disability, what do you think are the greatest barriers experienced by people who have a disability are when accessing the workforce? You can either think to yourself or you can put your ideas in the chat or the Q&A. But we know from the research, the biggest barriers are, if you click, it'll pop up on the screen, myths based on disability inclusive hiring. So things like underestimating somebody's capacity or capability, or overestimating the accommodations that are required. And also employers' fear of the unknown. So let's go over some quick information on disability in the workplace. So a survey by the Valuable 500 found that only 3% of leaders openly discuss their disability or primary caregiving role in their organization. So think to yourself, have you ever had these conversations? Have you ever set the tone? Have you seen senior leadership do this? That same study found that 46% of employers in Canada do not report on the number of employees who have a disability. And according to the 2023 Ontario Economic Report, only 44% of organizations have a DEI strategy in place that prioritizes accessibility. At Odin, we actually have a podcast called You Can't Spell Inclusion Without a D, because often the D in DEI does not include disability. So that same report identified that 78% of employers agreed that mental health was important to their organization's success. Only 37% of employers had a formal strategy to support employees' mental health. So I really encourage you at this time to reflect on your own experience with disability and your connection to the disability community and in your workplace, and think about whether or not your organization has a reporting strategy. If you have accommodations in place? Do you have a DEI strategy that includes disability and mental health as well? And I want to remind everyone, one of the importance of this is not just, for that individual who has a disability, but a 2020 survey found that 70% of job seekers want to work for a company that demonstrates its commitment to DEI, which helps make that company an employer of choice. And especially with trying to attract talent, that can be a game changer and set an organization apart. So at Odin and OCTC, we really like to view disability inclusion as a journey. And while compliance is a part of accessibility, fostering a truly inclusive workforce is an evolution of steps over time. To get started on your journey, I've got a few ideas to help get you started, depending on what challenges your business is experiencing and where you're at in your disability inclusion journey. So the first one is learn about the myths and misconceptions around disability. If you don't have a lot of experience with disability, consult with an external DEI professional who can help you raise your disability competence level and take the first steps towards disability inclusive hiring. If finding and accessing qualified candidates for your roles from the disability talent pool is a challenge, building a recruitment relationship with a local employment service provider can be a great place to start. And then review your job postings for inclusivity. Beyond including an accommodation statement, which is important, there are a number of ways you can ensure that your postings don't pose invisible barriers that can be deterring people who have a disability from applying. And finally, you folks know better than most that employee retention is a journey that begins on the first day of work and continues. And by scheduling regular check-ins, you can provide ongoing support throughout your employee's career with you. So if you need help with exploring any of these tactics or more to transform your workplace into a more disability inclusive environment, there's a variety of ways that OCTC and Odin can help. So the first one is to learn. So Odin offers disability awareness and confidence training to support your disability inclusion journey. We do this in person, online, and then OCTC. Although our project is ending, there's always new ones beginning. You can discover Odin offers corporate memberships, which include both training opportunities and additional services to help support your HR activities. So things like inclusive job posting audits, interview coaching, and a lot more. You can access a collection of free business resources on our website pertaining to research, reports, case studies, tip sheets, and guides. And then finally, ESP relationships. Odin has a large network of ESP providers to connect you with who specifically work with folks who have disabilities as well as folks who don't. And our membership is listed on the Odin website, so you can access that at any time.
Kirsten, there was just a question
Yeah.
that came through. Where do we find a listing of ESPs so that our talent acquisition team can advertise our roles?
Fabulous. Our entire membership list is on our website. You can search by region. There's a map. You can look for different providers. Every community, just about every community and region across Ontario has an employment service provider that you can connect with. And more than just, posting a job. It's not like a job board or something. Connect with one of the job coaches, business developers, and reach out and really develop that relationship because it goes beyond just having a candidate. They provide so many more services to support their job seekers and support a business particularly when it comes to hiring somebody who has a disability and navigating some of those conversations. So I'll be happy to share a link in the chat as soon as I can pull that up to make sure that you all have that. Awesome. Thank you. That's a great question. Were there any others that I had missed so far?
No, there was just one.
Okay, perfect. So there are two additional ways that I want to share with you today that we are very excited about. And it's all pertaining to disability inclusion in the fall. So first, NDEAM. So October is National Disability Employment Awareness Month, starts October 1st, and it's an opportunity to recognize and talk about employment inclusion and collaborate to increase inclusive hiring. One of the core activities of NDEAM is the National Light It Up for NDEAM campaign. On Thursday, October 16th, cities, businesses, monuments from coast to coast to coast lighted up for NDEAM in purple and blue, spotlighting disability inclusive employment. It started in Ontario 6 years ago, and it has spread across the country, and it's one night. It's free for anyone to participate in, any business, any organization, any individual as well. We do have a PR kit available on our website that shares more information and where to register and sign up. Your team can wear purple and blue for the day, take pictures, post on social media, and you can sign up on the website as an official participant. Last year, I think we had over 400 businesses across the country participate, businesses, municipalities. I'm sure if you go look at the video on our website, you may see a monument from your community or a location. Our whole team disperses. We're a provincial-wide organization, and we take pictures of everywhere that's lit up, and everyone can submit. And then the other one, if you can flip to the next slide, is just want to share that we have our annual Rethinking Disability Conference, RDC 2025, coming up. It's a 3-day conference designed for employment service providers. However, we have a 1-day business stream exclusive for business leaders at all levels of organizations. It's on Monday, November 3rd at the Sheridan Parkway North in Richmond Hill. And the agenda for that day includes our 2-hour disability awareness and confidence training provided by our capacity building team. There's also a great workshop on disclosure and accommodations. And there is a networking event where you can network with each other, with local employment service providers. And I will be the one leading that session this year. And we are going to be joined also by Beverly Bowerman King, resiliency, stress, and organizational wellness expert, as our keynote speaker. And that is sure to be a fantastic day. It's always interesting to participate in. I've just got a link for that in the chat as well. And then if there's any questions or discussion, we can do that now. I really hope I've left you with a better understanding of disability inclusion in the workplace, just some food for thought to get your journey started, why it's important, how you can get involved or deepen your journey. So thank you so much for having me here today. I really appreciate the opportunity.
Of course. Thank you so much for sharing the presentation and all of this information with us. We appreciate it. I know we're 15 minutes ahead of schedule, which is great. Everyone can have some time back in their busy schedules. But before I let you go, I do want to launch a quick poll. We are planning our sessions for 2026. So just going to launch it and just interested in what topics or themes you'd like to see in the upcoming year. So if you can take a second to do that, that would be wonderful. You can select as many as you wish. Everybody sees that? Okay. Perfect. Okay, lots of leadership and people management interest. Amazing. All right, so we are going to wrap up. Thanks again, everyone, for joining, and we will see you in October. Enjoy the rest of your day, everyone. Bye for now.